This is Technically Legal, a podcast about legal technology, innovation in the legal industry, and the impact tech is having on the law. I'm Chad Main, the founder of legal services company Percipient, and on today's show, talking to e-discovery expert and attorney Kelly Twigger about her practice, her history in electronic discovery, and her newly renamed company, Minerva 26. I bet many of you out there listening are familiar with electronic discovery, or e-discovery as they call it for short. If you're listening somewhere outside the US, like in Europe or Australia, you might even call it e-disclosure. If you're not familiar with it, I'll give you a high-level overview. In litigation, you have a few main stages. You got the pleading stage where filings are made to get the case started. Then you have the discovery phase. There might be a phase after discovery where the parties try to get the court to make a decision on the case before trial, and if that doesn't work, then there's the trial phase. I bet you won't be surprised to hear that e-discovery is part of that discovery phase of litigation. So what is the discovery phase of litigation? It's just that. The parties are trying to discover information that can be used as evidence at trial. Back in the day, discovery was just depositions and the parties exchanging documents, hard copy written documents. So one party would take their box of documents to the attorney, and the other side would take their documents to their attorney, and the attorneys would go through it and figure out what was relevant to the dispute, and they send the other side copies. Fast forward to the late 90s, early 2000s. People are starting to move away from paper and they're sending emails. They're using Microsoft Word and other word processing programs. They're using database to store their business information. That's where the electronic comes in. It's no longer paper, but it's electronic documents, e-discovery. And on today's show, I have a good friend of mine joining who's an e-discovery OG, Kelly Twigger. She's the founder of ESI Attorneys, e-discovery assistant, which was newly rebranded Minerva 26. Kelly and I talk about all things e-discovery, starting with her journey when she was an associate to a few years later when she left firm life and created her own law firm, ESI Attorneys, which focused on legal work related to electronic discovery. Ultimately, she launched a software company called e-discovery assistant that has now become more full service and branded as Minerva 26. You can think of it as a strategic command center for e-discovery that curates a database and dashboard for case law, relevant e-discovery rules, checklists, and offers on-demand education. Kelly and I are going to talk about why attorneys should be proactive in e-discovery, because the earlier you get started, the more you learn and the more money you will save. Kelly's also a very firm believer in technology's transformative power. What does she mean by that? She explains that ESI, that's electronically stored information, unlike paper, offers immense opportunities to leverage tech for more efficient and effective legal analysis and fact-finding. She and I also talk about what hinders lawyers generally from adopting technology, which is fear and expense. Finally, Kelly talks about with the advent of new tech, AI, and more volume of e-discovery, it might be time for the courts to yet again change their e-discovery rules.
I got into e-discovery back in 2003, 2004. Happened to go to the first ever ABA event on e-discovery, and it was a really small room of maybe 15, 20 people, and Judge Shinlin was there, and we were talking about her initial decisions in the Zubilay cases and how she was making references to the Federal Rules of Civil Procedure and providing input to the Rules Committee on that. And I came back to Quarles, which is where I was a partner at the time. Actually, I think I was an associate at the time, and said, hey, guys, we got to pay attention to this. So we formed a really big team there of about 24 folks, combining litigation, records, knowledge management, corporate folks from a due diligence perspective to form what we called the Red Team. And we started advising clients. And so that's really how I got into it. And then I became sort of the de facto person for reviewing all the technology that was coming out. We first started seeing we were working with summation then, of course. And then we started seeing all the technologies that were growing. And I became sort of the vetter of technology for litigation for these kinds of tools. And then I grew our practice there. And in 2009, I left Quarles and formed ESI Attorneys, which is our law firm. And the law firm is exclusively e-discovery and information governance work. We act as discovery counsel for clients, but I've also done a lot of expert work lately and have been asked a few times that nothing's evolved in the special master universe, but I'm hoping to step into those halls as well. But for the most part lately, we've been focused on Minerva 26, which was our software platform. So what happened originally is once I built ESI Attorneys in 2009, man, the case law was just flying on e-discovery issues. I mean, whereas we normally have one or two substantive decisions a year in a given area of law, In e-discovery in the early 2000s, we had about 200 every year. And the technology changed, which meant the interpretation of the rules changed, and then the rules changed. And there are so many issues that are unique now to the discovery of ESI or e-discovery.
Did I see on the site there's 46,000 right now? 46,000 cases?
Yeah.
Yeah.
In the database. So anyway, the impetus for building the tool was I needed to be able to stay up on what the rules were in all the jurisdictions across the country, as well as the case law. So I built it for us to use internally at the law firm. And then we just started getting a lot of requests for it. So first we built it out as an iPad app. And then in 2018, we started building it out as a SaaS-based tool. And during COVID, we redid all the UX UI for it. So Minerva 26 is the new name. It used to be eDiscovery Assistant up until March. We just rebranded the company. And it's really your strategic command center. So whereas you've got tools to handle data, this is a tool for your knowledge, for your e-discovery strategy. It curates case law from across the country and organizes it by e-discovery issues. So you don't have to guess at the language or the search terms. Rules, checklists, and forms for all the processes in e-discovery, a glossary of terms, which surprisingly is hugely popular among our users. And then we have our academy, which is on-demand education. So trying to really solve a lot of the problems that we're coming up with at 10, 11 o'clock at night and don't know where to go to. You can go into the academy and be able to get some good answers there to move yourself forward.
You named it Minerva 26. Minerva is the Roman goddess of wisdom and law,
Yep,
and 26 is a nod to Federal Rule of Civil Procedure 26,
that's
which
exactly right.
underlies all discovery. Why didn't you just keep it e-discovery system?
A couple reasons actually, Chad, because one, folks were confusing us with data tools. So when we first built eDiscovery System back in 2012, it made a lot of sense to have eDiscovery in the name so people knew where it was, what it fit, and how it was going to help you. Now, when you have eDiscovery in the name, everybody thinks it's a data tool. And we needed to reposition it that way. But we also are building additional products at Minerva. And so we wanted to be able to have a more broader vision of the industry in legal technology for us to be able to expand on. Is there other things we want to build?
You mentioned some of it. Let's go through it. The start obviously was keeping track of e-discovery case law, and connected to that, you categorize basically like a Westlaw key site type of deal, like issues, right? Or is there a difference?
It's a little bit different. So, for example, if you wanted to find information on failure to preserve data from a mobile device, specifically with regard to text messages, you could go into our issue tagging structure and you could put in failure to preserve, text messages, mobile device. Click on those, and you'll get every case from across the country that has dealt with the failure to preserve text messages from a mobile device, and you'll get them organized on a map by jurisdiction, either by federal, state. We also have administrative case law. So what would take you hours to find in a larger research database that has all the content in it now takes you just a few minutes to get to the decisions you actually want to review. So cuts out the noise, if you will.
You have checklists, which you mentioned too. So if you going into a meet and confer, you have that
Yep.
kind of information.
Custodian interviews, what to put in your ESI protocol, what to really think about with regard to an ESI protocol, all the different processes in e-discovery.
Now, one of the things when you mentioned the name change, which I think was in March, right around
We announced it at Legal Week. Yep.
Legal Week, yeah. You mentioned in your blog post about it that Minerva 26 is designed to proactively manage the growing challenges of electronic evidence. And you note somewhere, I think in the same article, that most attorneys handle e-discovery reactively. When and how is that going to change? Because as you mentioned, you got into this in 2003. What, 27 years?
I have seen a lot of change. I've seen a lot of lawyers embrace it, but I'm going to frame that slightly differently in that here's what I think. I think ESI, unlike paper, gives you the ability to do way more with technology in the context of the case law and the rules than you could ever do with paper. So ESI attorneys has long been a solo shop, right? I mean, we hire contractors, we upscale for whatever we need for particular matters. But I don't keep a lot of employees on, I don't keep a lot of overhead. With ESI, I can make 5 calls, have all the technology I need in minutes to be able to deal with data, and I can do way more than you could ever do, with a staff of, like, 10 people. I mean, when I started with paper, we had paralegals, we had multiple lawyers, we had huge rooms full of data we could never go through. Now you've got the opportunity with technology to be able to know what your case is about and what the potential issues are from a fact perspective or a risk mitigation perspective like that. I mean, within weeks of identifying where an issue is, for employment matters, we get called in a lot to help us evaluate whether there's a claim here at the administrative stage. So if you know employment, all employment matters have to go through the EEOC, and there has to be an administrative finding before they can move to litigation. And we'll come in at that early stage and be able to do that analysis. And I mean, we could do that analysis consulting through Minerva, or we can do it through ESI attorneys.
Explain the difference, though. Explain how you're able to do it more effectively and more quickly with electronic evidence versus the old school way with paper and whatever.
Technology. Technology, right? With paper, you had to basically convert it back to electronic form in order to be able to deal with it. And the tools that we had then weren't so great, right? The OCR is so much better now. When you do have paper, you can do a lot more with it, and you could do it faster. You could do so much more faster if you have a ton of data sitting at Iron Mountain or something like that that you want to digitize. You're talking about weeks now as opposed to years is what it used to be. So there are technologies out there, tools that allow us to get into analysis of information. One of the tools that we really like is the ESI Analyst. It might be Cloud9 Analyst now. I've been looking at it and using it since they sold to Cloud9, but you can create a timeline in there. You can upload any different types of forms of data. So I can have an entire contents of a cell phone, email, everything, and they'll create a timeline for me of who was where when, right? And that sort of visualization of data is something that we never could have with paper. And you were very reliant on witnesses and their credibility. Were they telling you the truth? Now everybody writes everything down. I barely need a witness except to provide some context.
Going back to the original question, though, you use it because you're steeped in it. I would say obviously more people use it than, say, 10 years ago. But personally, I feel, and tell me if you disagree with this, I think the vast majority of attorneys are still, they kind of know that the software's out there, but they don't want to take the time to use it.
I think that it's fear. I think that it's fear and it's expense, right? And that's where we really are trying to change that thought process, that we would like you to think of it as the power of ESI instead of the burden of ESI. There's no question that the volumes of data that are available and the myriad of sources that you can get that data from make it very difficult. But if you just get a plan for the cases that you handle, the types of data that you see on a regular basis, and work directly with your clients and whatever expertise they already have to do that internally, you can do it a lot more effectively. And part of what we're doing at Minerva is helping identify those technologies to our users so that they can leverage them effectively.
So I'm going to step back a little bit. What was the biggest challenge or thing you didn't think you would run into starting a company versus practicing law, even starting, ESI attorneys? Like what have you learned, or what didn't you expect, or was it as hard as you thought it was going to be, or was it easier?
Well, it's definitely harder, right? Because you don't get a paycheck as much as it's dependent on what you do, especially at the law firm. But that's true of every law firm. But when you're a partner or an associate at a law firm, you have a job, right? I like the freedom to be able to make decisions and pivot constantly when necessary. So I really enjoy that. I like being able to move with the market, and I like being able to set up a business model that isn't tied to what a larger entity is doing. So one of the initial reasons that I started ESI Attorneys in 2009 was because the business model of e-discovery was, let's have more and more and more data and spend more and more and more of the client's money. And the most effective way to do e-discovery is to do it economically and efficiently with the right technology and the right knowledge. So that was really why I made that change initially. And that's what we promote now. And I see it a lot more, although it's interesting. I mean, AI is really changing things, especially in the review world. And the question is, how quickly is that changing? And are the people who were providing services in that area willing to adapt to those changes and embrace them? Or do they just want to make as much money as they can?
That's an interesting question. Obviously, it's one of the things we do is big reviews and stuff. But so this is what I mean. It's early days, real early days.
Absolutely, 100%.
And I agree with you 100%. It's gonna change where you needed back in the day, you needed 50 people. Now you probably need 15 because of the tools you can use in the front end to do it. But and AI is gonna change it completely. I think it's probably gonna be a subject matter expert and a couple reviewers are gonna get the job done. But here's what's interesting. I think that the companies, at least we're definitely willing, and we're looking at all kinds of stuff all the time. The pricing model will have to change. But what I'm still see is that fear, right, from the lawyers because they still think, they got to look at everything. I think that might slow things down. Do you agree with that, or do you not agree?
I do. I think fear is a huge problem, right? Fear of e-discovery generally, fear of technology, fear of not looking at everything. I mean, and to your earlier question of when is that going to change, it has to be education, education, education. And that's another challenge, if you will, problem, Because I never met a single lawyer who has enough time in the day to do more education, to do whether they're the ones teaching, unless that's their job, one of their jobs in the organization, or to participate, right? It's hard. And this stuff is moving so fast, right? You almost need to be doing an hour a week of somebody giving you really targeted education on what's happening this week. And that's not going to happen. We lawyers have too much to do as it is. I'm not one of those people who ascribes to the notion that AI is going to replace lawyers. But what I will ascribe to, and I already see it all the time because I use AI a lot every day, and that is it will improve a lot of the things that you either weren't doing or you could do better, faster, stronger. And we've already seen a huge downtick in the amount of administrative support that law firms have over the last 5, 10 years. And I think that's going to increase. The challenge is that law firms still have such disparate systems and they don't talk to each other, right? And that's the problem with all software. It's not just a law firm, it's entities, organizations as well. But the lack of ability for that software to talk to it means that somebody has to constantly thinking about where to put the data and how to organize it and how to keep those systems moving. And that's not going to be the lawyers. That's not what they get paid for. So there has to be some support there, but I think the nature of that support is going to change, or the assistants, the paralegals, the legal assistants are going to need to become more educated on the technology and how that enhances the law firm's capabilities.
Going back to the Minerva 26, I know consulting is a piece we haven't touched on too much yet. What kind of consulting does the company do? They provide the platform, they like the dashboard you go to, all your e-discovery questions answered one place, but you also provide services too.
Yeah, so we consult with other folks that are building legal technology to get a lawyer's perspective. So typically I'll consult with them on what that looks like, right? When they show me, here's what we're building. And I'll say, okay, well, lawyers are going to want it to do this, 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 and this. And this workflow needs to change here. This visualization needs to be slightly different. I want to be able to see this at a glance, these kind of things. So I'll do consulting for legal technology that's being built. We'll also consult if it's not a legal-based consulting. So legal-based consulting, I do at the law firm, if you need the legal piece of it. But anything else in the space, how to set up departments, how to implement the technology effectively, how to train people on the technology effectively. We do create a lot of training videos. So a lot of different things that you can think of. Essentially, if you want a lawyer who's built software and knows e-discovery, that's where we fall in.
Going back to the training, so what do you tell in-house legal departments, law firms that are trying to train their attorneys to be more adept with e-discovery? Like, how do you tell them to approach it? Like, what needs to be done?
Well, we do training programs. So if we're talking about training lawyers, training associates, then we do training programs. So we offer on-demand stuff is available through Minerva 26, but we do 1 and 2 day training programs for lawyers that will come on site, and we have multiple hypotheticals that we use depending on the needs of the law firm and whether there are multiple groups. We have to limit it to 10 to 15 folks a day. And so we'll do on-demand training programs where we literally take a hypothetical and walk you through the e-discovery process for that hypothetical all the way up to trial.
And then going back to the on-demand videos, what kind of topics do those cover?
So everything that we cover in person, and that training program will actually be released in July in the Minerva tool, and it's a separate subscription to the tool itself. That will cover the same thing, but it'll be in an on-demand video format. So it'll be something the user has to work along with through the hypothetical, and it's good. It's not as good as in-person interactive where you can ask questions, really engage in the exercises. So in the in-person training, we do custodian interviews, we do meet and confers, we do the pieces that you need to be able to think about so that you're using the language, you're not just listening to me talk.
We talked about what has changed since 10, 15, 20 years ago. What is not, and what is one thing you wish would change, and you tried to make that change in the e-discovery world?
There's a couple things. One, you raised it earlier, and that is the lack of lawyers wanting to get in and really utilize the power of ESI. I love to see that grow and expand more. I get involved in cases where I just think, wow, we could have done so much more for so much less money if we'd gotten engaged early on here. So that's one. One, I'd like lawyers to really get into it.
That's one takeaway from the podcast today. Start early. You're gonna save a lot of money and time.
Yeah. I mean, a lot of what I do is people call me early on in a case, and I'm a discovery strategist. So people call me early on in a case, and I say, what about this? What about this? What about this? If you've got third party subpoenas, you need to send those out now because they're going to take months to get through and you've got a shortened schedule. Let's talk about whether you need an ESI protocol or not. All these issues, right? So there's essentially a checklist of things you want to go through at the beginning of a case, of things you need to spot and issues that you need to solve. Retention, preservation, all of the things, right? I mean, you and I know them like the back of our hand. I'm not sure if the audience does, but the later you start in e-discovery, the more it will cost you and the less you're going to get out of the information that you get. And by that, I really mean form. So when you don't ask for the right metadata fields from a particular source of ESI, whether it's social media or Teams or Slack or anything, you lose the ability to filter on specific types of data. You lose the ability for your team down the line to use that data effectively. So there are really crucial decisions that are made in the early months of litigation that need to be thought about effectively.
You know, kind of related to this piece, you mentioned cost because the earlier you start, the less you're going to spend and be behind the eight ball and get in trouble with the court. But I think a lot of change could be affected by clients pushing their law firms to change the way they handle this or even bring some stuff in house. I don't think that happens enough. Do you agree or disagree with that?
I agree with that, but I will also say this. I've seen a couple of things. So our corporate clients on the Minerva side and also on the ESI attorney side, they know what they know and they know what they don't know. And they are willing to say to people, here, we have this. What do we need to do? So it's that. But two, it's also they don't have the time, right? I mean, I talk to many, many in-house counsel who say our outside counsel are abysmal at e-discovery, and we know they're abysmal.
Part of the reason too, I think, is outside counsel. I know this is generalization, but I think there's some truth to it. Where you just said a lot of in-house attorneys will say, "We know, we don't know." I don't think law firms say that enough. Then they try to keep all that stuff in house.
It depends on the firm, of
Yeah,
course.
agreed.
We have a lot of clients who are law firms, and I don't want to diss on law firms because the reality is nobody's making a decision not to be good at e-discovery.
Right, right,
They're not
right, right.
making that decision. They are caught in a loop of must make money, must keep servicing clients. And it's hard to step back in the law and say, if I invest 20 to 40 hours or $50,000 here, I'm going to reap that going forward. That's never been a business model of a law firm. I will say that I think that's changing. We're seeing a lot of law firms that are retaining chief innovation officers. And those are people that we talk to for use of Minerva. And I think as they do that, then those innovation officers are the ones from a business perspective who are looking at how can we improve what we're doing here? And they will be the ones to do that. So I think the business model at law firms has not supported the kind of change that's needed to implement e-discovery effectively. And lawyers are so busy. So I just want to be clear that yes, it's a challenge. Yes, it's something that needs to happen more and better. And it's frustrating perhaps for you and I who've been in it for so long. Why isn't it happening? But I think it's not happening because it's a different kind of business model than lawyers ever learned. And nobody teaches us business in law school.
Right. No, that's true. And I think that's changing a little bit at the law school level, but certainly not enough. Well, let's step away from in-house and step away from law firms. The bench. Do you think the bench is more knowledgeable about e-discovery today compared to 5 years ago, 10 years ago? And this very specifically, I want to ask about the technology and how it actually works and not how the rules work and what you're obligated to produce, like how the sausage is really made.
I think that very much depends on the judge. And I would say a couple of things. When you started your question, I was going to say yes. I think
Right.
that the bench is infinitely more knowledgeable about e-discovery issues now than they were 10 years ago. So I do a case of the week every week. I think I moved it to every other week now.
It's a podcast you post on LinkedIn. Yeah. Yeah.
It is a podcast. It's been called the Case of the Week, but like the rebrand to Minerva 26, we're rebranding the podcast to be called Meet and Confer. So starting next week, it'll be called Meet and Confer, with the Case of the Week being a segment on that podcast. And so the Case of the Week segments will just be me doing the analysis of an e-discovery decision. And if you search right now, you'll find the Case of the Week podcast with Kelly Twigger. So to stay with the judges, there are a lot of judges who get it. But the judges suffer from the exact same problem that the lawyers have, is that they don't have the time, inclination, expertise, people telling them to learn the technology. And it isn't the judge's job to learn the technology. It's the lawyer's job to explain to the judge what they need to know for the outcome of whatever they're bringing to them. And so on the technology, no. I would have to say blanket, no. I don't think the judges necessarily know and understand how the technology works. I think that some judges are better at it than others, but I will also say, in having read a lot of decisions, in particular about hyperlinked files over the last 2 years, because that's the latest really technical issue that's come up, what the parties tell the court becomes part of the
Yeah.
record, and sometimes it's not
Yeah,
accurate.
and as I ask that question, I go back, I say, do the judges know how the sausage made? At the end of the day, they probably it's not really their responsibility.
It's not their
There's
job.
just a lot of discovery disputes based on, you just intimated it there, inaccuracies, lack of information about how the tech really works. I think back to you and I are both part of that Seventh Circuit pilot program, and they had part of that was
Mhm.
the mediation. They had ESI mediation, which I think was underutilized, and I don't even know, does it exist anymore?
I'm not sure too much of the Seventh Circuit pilot. It's just so the audience knows, it was the Seventh Circuit e-discovery pilot project. It started in 2009. And yeah, I was on it originally, did a lot of drafting of documents with folks. And I don't think that that pilot project is still even out there. But it was incredible, and it brought a lot of knowledge to the judges in the Northern District of Illinois in particular, and there's some great case law out there as a result of it. But again, in 2009, and let's take 2009 maybe to 2015, we weren't talking about the technology shifts that we have seen for the last 10 years. So the pandemic and the shift to Teams and all the different types of data that exist in Microsoft and that Teams environment, the use of collaboration tools like Slack and all the project management tools that we use for everything, and hyperlink files, the use of web-based email instead of using a Microsoft server-based email. So much has changed technologically that it's just like this. It's a straight up like here, and everybody else is like here. So if you look at knowledge versus what's happening, it's not even a curve, it's a straight line up, and the knowledge isn't necessarily going along with it. So for the judges, I think some that you asked earlier about what needs to change, I think we need some updates to the rules. In particular, we've got judges across the country who are completely split on, does an employer have control of an employee's personal phone if they use it for work-related information that is clearly relevant to the context of the litigation? You've got one judge in particular in the Miramonte case says, look, we can't think about this the way that we've thought about possession, custody, or control historically, because it just doesn't work like that anymore. Business moves at a light speed. Since the pandemic, everyone texts. It's the fastest form of communication. And then we've got other judges that are relying on the legal right and the practical ability test under possession, custody, or control under Rule 34. And how do you make an argument when you've got multiple judges like this? And these aren't decisions that are going to go up to an appellate court. They're not appealable decisions that we're going to go and get some solid law on. So there needs to be some changes to the rules. I've had some conversations with some judges about the need to revisit some of those things. The current climate in the United States is not particularly conducive to the judiciary. And so there are a lot of outside forces that are impacting, cuts in budgets are impacting. So it's a tough row to hoe, but I think the judges
No,
try.
they do.
I think they give it everything they can give it. And some of them I think must get really, really tired, particularly the judges that are in the Northern District of California that have to deal with all of the class actions against Google and Facebook and all the tech companies that are headquartered there. They get inundated with these decisions so much. And it really should be incumbent on the parties to do their job. The case of the week that we covered last week, that'll just go out to our subscribers today, is from the NRA Metapixel healthcare litigation case. And it's all about cookies. And why can't the parties come together and figure out a plan for how to provide cookies in the litigation? Why do you come to the court? How is the court supposed to know about how
You're going
cookies
back to
are
how the
achieved?
sausage is made. That's some
Right.
really crazy code-based stuff.
I mean, you do a lot of forensics, so you know that how you get cookies depends on the browser and depends on the device that you're on. So for every browser and every device, you've got a different way to go about getting cookies. And in that particular case, there was a big argument about the scope of what should be relevant. And maybe they should have done it earlier. I don't know. It's a big cluster, but that's a really good example of how the judges don't know how the sausage is made, and it's not their job to. We think I'll just add this one point because Judge Goddard from the Southern District of California is always raising this with me, and she's like, Kelly, you got to remember that these big civil cases and these e-discovery decisions that you guys read and you hang on, these are like less than a third of what we do on a daily basis. And so the idea that we can be e-discovery experts like you and know all of this stuff, it's just not ever going to happen. It can't happen, you know? And so it's got to be the lawyers that bring to the judge what they need to know and why they need to know it. And I see a lot in the case law of just sort of spurious arguments, throwing proportionality at the wall to see if it'll stick with no underlying facts about why something isn't proportional. The courts are saying no. The courts are saying, you got to bring me some facts. I'm not going to, or no.
As we close this out, we talked about it earlier. We got to talk about AI. How are you really using it today? Generative AI.
I use AI today a lot in writing, adding in here's the information and factual information that I have. Of course, we don't use it on the ESI side because it's open source, right? If we have a closed loop system that we can use, then we'll use that. But right now we use the open source. So we use it mostly on the Minerva 26 side. We use a lot for marketing within the application itself. We have it plugged in to summarize every single one of the 40 some thousand decisions that we have in the eDiscovery database. I also use it to improve any of the learning and the training transcripts that I have. I'll use it to add additional information to what I already know and have included in those. We also are creating a human in the loop series. The way that we add case law to our backend database is very manual right now.
Yeah, how do you do it? I was going to ask, how do you keep up on everything?
So we have a number of different sources that come into our backend database via whatever search terms, algorithms, API calls, whatever they are. They come into the backend database, and then we have to decide, do they go in our database based on our parameters? And then what are the issue tags that get applied to them? So we add issue tags and we add related information. So like if a case analyzes Rule 26 or an obscure local rule from a court in California, those will be issue tagged together with the case so you can have a full picture of what you're looking at as you go through the case. Our team does that a lot right now. It's very manual. And so what we're building is, because the reasoning capabilities of AI have improved so much over the last year, we're building what's called a human in the loop system. So the AI will be able to take a first pass at it, and then the human will continue their review and be able, whatever information the human provides, it will go back into the training loop. So what in eDiscovery we might call computer assisted learning. But the advanced reasoning capabilities of AI are just off the charts. I mean, they've improved so much in the last 6 months. I'm really anxious to see what they're going to be in the next 6 months. The other thing that we're building at Minerva is taking that same reasoning capability and creating a RAG, fine-tuned instance of RAG to be able to create what we'll call Ask Minerva. So that will allow you to come into the dashboard and literally just ask a question. And it will give you a response, and it'll also link you to all the information within the Minerva 26 tool that you need to take a look at. So if you come in and say, Judge Kim in the Northern District of Illinois has ruled on proportionality, then you would be able to put that in, and then the system will immediately know to run an issue tag search for case law and bring back those results. So that's what we're working on building, because that technology is advancing, and that's like a Q4 sort of implementation for us.
That'll be great.
So we have a number of ways in which we're leveraging it. I'm always looking for new ways. There's a lot more talk about AI than there are capabilities.
Especially in e-discovery, when you actually talk about the e-discovery work, because the back-end tech, right? It's just not there to process the volumes of information that e-discovery software does today. Once that happens, that's the game changer.
I would agree with that.
Who knows when that's going to happen? I just don't know.
I think what you have to remember is that the legal sphere, even though to us it's our whole workplace, right? It's like a drop in the bucket compared to the applications for AI across the universe. And so you got to have the right people interested in investing in that. I think Harvey is doing a lot of that on the AI side. There are a lot of tools out there that are implementing AI into them, especially for contract lifecycle management, CLM tools. And they're great uses for it. Absolutely fantastic, great uses for it. On the litigation side, you've got summarization capabilities for deposition transcripts for
Oh yeah,
documents. The summarization for documents, if you're willing to pay for it, whether you're in an Everlaw I'm not sure, but Disco might have it. Relativity certainly has it if you're willing to pay for it. And Reveal may have, I'm not sure. I'm not trying to diss any platform. I don't know what all the platform's capabilities are there, but the ability to see a summarization of the document. Now, that's a good thing, but I can also tell you, as someone who's summarized 40,000 case
Right.
law
It's
decisions,
going to miss stuff.
it doesn't get everything that you want it to get. We have re-engineered the prompt for those summaries. Let's see, we introduced that in September 2023, so right after ChatGPT came out. We've re-engineered that prompt probably 4 times to be more clear, more consistent. I do find that the reasoning models, as they expand, they do better summaries, but every week I get a report from my team of random generated 50 summaries from cases, and I read them and I go, we need to tweak this a little bit, or we need to do this. So it's not a quit it and forget it kind of situation. And I don't know how the back end of those summarization tools within e-discovery platforms are working to be able to give you an opinion on that. I think there's exponential capabilities, but I also think if you're using them, you have to be prepared to explain how they work to a court or to the other side. That almost brings me back to a point I made earlier about the rule changes. We're still having fights about whether if I choose to do TAR, I have to disclose that to you.
Technology assisted review.
Technology assistant review, right. And TAR's been around since, I don't know, 2012, 2015 was when I think Judge Peck said, "Yes, I bless, bless TAR." So, I mean, the rules aren't clear enough on what needs to be disclosed. I would argue under Rule 34 that I don't have an obligation to tell you how I'm gonna meet my
Yeah,
Rule
I agree.
36
I
obligation.
agree. I agree 100%.
On the other hand, if I'm on the plaintiff's side and you're telling me you're gonna use TAR and I don't trust you, but you need to have legitimate facts for why you don't trust someone that you can go to the court with in order to have that dispute and that argument. I've had success as an expert with some folks arguing that there needs to be more transparency in the TAR process, but with a factual basis that necessitated it. So my point is that with all this development in technology and the use of AI, we're going to have a bit more clarity in the federal rules. The problem is it's kind of like administrative law, right? We need to make one rule that governs all, and there are always going to be side cases, or as my development team would call them, edge cases that don't fit within the rule. And you've got to figure out how to jerry rig it into there. So the trouble is, who's going to do that, right? I mean, and you have to have people knowledgeable enough with the issues to advise a rules committee on how to make those changes. And then we've got to make sure they benefit both defendants and plaintiffs. We had some struggle with that in the last rounds of the amendments to the Federal Rules of Civil Procedure, that the plaintiffs really felt like they got hosed.
Kelly, appreciate your time.
Thank you.
If people want to get a hold of you, learn more about Minerva 26, where do you want it to go?
You can drop us a line at info@minerva26.com. It's MINERVA 26.com. If you want to reach out to me directly, I'm at kelly.twigger@minerva26.com. Love to have a chat with you about anything we can help with.
Okay, that's a wrap for today's episode. As always, we really appreciate you listening. If you want to subscribe, you can find us on most major podcast platforms like Apple, Spotify, Google, Stitcher, etc. Also, if you like us enough, I hope you leave us a favorable review. Thanks again for listening. Until next time, this has been Technically Legal.